Now, Penal Code Section 243E1 is one of two domestic violence laws in California, and it's considered the lesser of the two, or the less serious, the sort of the light version of domestic violence. The reason it is because it can only be charged as a misdemeanor. It could never be charged as a felony, and it does not require the prosecutor to prove that there was a visible injury. Now, it certainly would make the prosecutor's case stronger if there was a visible injury, a bruise or a welt or a cut or a laceration. But technically speaking, you could be convicted of 243E1 even if there's no evidence of a visible injury on the victim. If you're convicted of domestic battery under Penal Code Section 243E1, you would be put on probation. You could face up to 6 months in jail. Usually a lot of prosecutors' offices have a minimum 30 days in domestic violence cases. And you would have to do a 52-week domestic violence class where you go once a week for a year. But perhaps the worst repercussion of a conviction for this offense is that it goes on your permanent record. And when an employer sees that, and employers do a background check practically in every case now, a conviction for domestic violence is a real red flag, because an employer will wonder, is this person temperamental? Is this person violent? Are they dangerous? Are they a liability in the workplace? And as hard as it is in this economy to get a job at all, it certainly is going to hinder your chances tremendously if you have this on your record. So if you're charged with domestic battery, you want to do everything you can now to fight the case and to keep it off your record and avoid being convicted. And the good news along those lines is that here at Shouse Law Group, we've had a great record of success in getting this very charge reduced or dismissed. And what we find is that a lot of innocent people get wrongly charged with domestic battery. And we see this for a number of reasons. Sometimes we find that our client really acted in righteous self-defense and wasn't trying to hurt the other person, but was literally trying to protect themselves. Sometimes we find that there was a striking of the other person, but it was really accidental. So maybe there's a heated argument and some shoving goes on, and somebody gets hit in the face, there's arms flailing, but our client wasn't trying to strike the other person. It was a genuine accident. And a lot of times we find that there were false accusations. Usually these cases arise in very turbulent times in a relationship, when a divorce or breakup is pending. The other person wants to get the upper hand in divorce or child custody proceedings, and they make a false accusation against our client. We see that all the time. And unfortunately, police, when they respond to a domestic violence call, they have a tendency to really jump to conclusions. First of all, that they're much more likely to arrest the man than the woman, even though many times the woman was the aggressor in the situation. Also, the police have a tendency to take the person who called the cops, who made the 911 call, and sort of brand them the victim and automatically assume that the other person was the aggressor or the perpetrator. And the police rarely get both sides of the story. They rarely do a full investigation. They tend to just rush to judgment, and a lot of times the wrong person gets arrested. But that's where we come in. Our job when we have a client in this situation is to take their side, to present their side of the story to the prosecutor and the judge, and even the jury if the case should go to trial. And when we've done this historically, we've had a great record of success in getting domestic violence charges reduced or dismissed.